Jim Jordan, the chair of the House Judiciary Committee, is demanding of the Justice Department a memo outlining the scope of the probes of former President Donald Trump. That would be, as far as we know, 2 probes, the 2 grand juries, D.C. and Miami, for the documents at Mar-a-Lago, and the other for Trump's involvement, if any, in the events of January 6th at the Capitol building. This memo, of course, will never come forward. This is what's called work product. This is the impressions of lawyers analyzing the facts that FBI agents brought to them, to the law that the Congress has written, to be presented to Jack Smith, the special counsel, to be presented to Attorney General Merrick Garland, who will decide whether or not to let Mr. Smith and his team seek an indictment before the grand jury. In my opinion, they have decided to seek the indictment in both cases. And in my opinion, Merrick Garland, the Attorney General, will say yes. The question is, can the House Judiciary Committee get their hands on the thoughts, the impressions reduced to writing by the special prosecutor's team before they seek the indictment? And the short answer is no, and the long answer is no. This type of work product, the federal lawyers' internal thoughts reduced to writing, their analysis of should we or shouldn't we indict, what is the evidence for indicting, what are the reasons for not indicting, this is never revealed. It's never revealed to a judge. It's never revealed to the defendant's lawyer. It would never be revealed to the House Judiciary Committee. If they subpoena it, the DOJ will either just ignore the subpoena or move to quash it. At the same time this is going on, the House Judiciary Committee has voted, or is in the preliminary stages of voting, to hold Chris Wray, the director of the FBI, in contempt for failure to produce a document which allegedly demonstrates that Joe Biden, when he was the vice president of the United States, took a bribe. Obviously, I haven't seen the indictment or the document. The committee hasn't seen the document. The committee had, not has, had a whistleblower who said she saw the document. That whistleblower has either changed her mind or absconded. They can't seem to find her. Can the committee get their hands on that document? Okay. Can the committee and can the House of Representatives hold Chris Wray in contempt? Remember, there's 2 types of contempt, civil and criminal. Civil contempt, I don't think Chris Wray could care less what a Republican House decides is civilly contemptuous, just like Eric Holder, the Democrat Attorney General under President Obama, couldn't have cared less what a Republican House decided he did that was allegedly contemptuous. So holding an official in the executive branch in contempt for failure to produce a document, the official in the executive branch will just brush it off his or her shoulder. If they really want to hold Chris Wray in contempt, they would have to persuade a federal judge to allow Chris Wray to be prosecuted for contempt. And at the end of the prosecution, the judge would order him to cough up this document. And then if he doesn't do it, he goes to jail. Would a judge allow such a prosecution? We won't know unless the House Judiciary Committee tries it. Is the House Judiciary Committee serious about holding Chris Wray in contempt? Not if they're just going to do the civil contempt. The only serious contempt, the only one that bites, that stings, that changes the career of the person being held in contempt, is the criminal contempt, and that can only come when the courts are involved. So I happen to like Jim Jordan. I think he's got tremendous courage, but I'm not sure he's serious about holding Chris Wray in contempt. If he were, he knows. I don't think he's a lawyer, but he's got lawyers that work for him. He knows that the only serious contempt, the only one that bites, the only one that stings, the only one that truly produces what you want is the criminal contempt.